Hello, everyone. Thank you so much for joining us today. We are happy to have you here. We're going to be starting in a moment. My name is Udochi, or Udo for short. I am one of the co-founders of Bias in African Fashion, and we, again, are happy to have you here today. I'm going to do a brief intro of ourselves and our partners and why we're here today before we get fully into the program and as we give people a chance to join us today. So let me share our screen again so that I can present the brief intro for all of us. So let me just share a little bit about BAF. I know many of you guys received our flyer, heard about the program likely through one of our members here today. But Bias in African Fashion is a fairly new organization, started just about a year and a half ago. And our purpose really is to help to create dialogue around issues of prejudice, bias, abuse in Africa's fashion sector, with the aim of really helping to ensure that the sector is inclusive and accessible to all, so that we can all participate and help to build our fashion industry to be what it really can be. So today we have a few partners who are working with us and putting together this legal project. Of course, we have my IP legal with Liz Lenjo, who is one of our speakers here today. We also have fashion brand Unkwa with the founder Unkwa Onukwa, who's also here with us today as one of the members of our team organizing this today. And then last but not least is the Fashion Law Summit Africa, and that is led by Sana Ahmed, who could not be here today with us, but has been a strong member of our team in putting together this project. And just to share a little bit about the legal project, and this is actually our second session. Some of you may have been at our first session that was held back in January. And the aim really is to have a series of introductory seminars, discussions, just to gear people up for what we have coming up later on in the year. As you can see with the timeline there, we're planning a legal clinic in April of this year. And these sessions that we are having, that we had last month, and also the one today, are really to help you as you look to take part in that legal clinic, to understand first the basics of fashion business, and then this one is to help you really understand the basics of fashion law, so that when we have those programs later on in the year, you can engage effectively with the legal practitioners that will be working alongside us. We'll share more about the legal clinic coming up in April towards the end of the program, but just know that that's one of the things that we have coming up and one of the reasons that we are having this segment today. And then later on in the year, August of this year, we want to launch a standing legal network of advisory individuals who can help those in the fashion sector really find resources to help you protect your fashion businesses and take effective advantage of the law in building your brands. So as we get started today, we just want to have a bit of an engagement with you, just to help us know who is in the room. We had a very strong response to this program, but just to help us understand better who is in the room, if you can just type in the chat just for a quick, brief engagement. Let us know where you're coming from today, where are you joining us from today? And secondly, what do you do? Let us know about your business. Are you, do you own a fashion brand? Are you a stylist? Are you a consultant? Are you more on the media side of the business? Just in a few words, let us know where you're coming from and what exactly you do. So I'm going to check the chat now to see if we have any responses coming in. Okay, great. I see we have somebody coming in from Nairobi who is a fashion student. Welcome. Thank you for joining. And feel free to send that message to everyone so that we can all see it. And as we're getting those messages, I'm going to ask Nkwo to prepare to introduce our speakers today so that we can start and go right into the program. We also have another student from Kenyatta University. Welcome, thank you for joining. Then the fashion brand from Nairobi, Kenya. Welcome, thank you for joining. Okay, great. Well, Kenya is very well represented here. Thank you for joining. Okay, great. Nice, law student from New York. Thank you. Okay, so I'm gonna move on as we still have those coming in. Please continue to type in the chat and let us know where you're coming from and what you do. I'm gonna hand it over now to Nkwo to do an introduction of our speakers. After she introduces them, we're gonna go right into the program with presentations by Anna and also by Liz. And we take questions after they speak. So if you have questions as they're speaking, feel free to enter them in the chat or hold on to them until after the presentation, and then we'll take them from you then. So I'll hand it over to Nkwo to do our speaker introductions.
So, okay, hi, hello everyone, this is Nkwo. So nice of all of you to join. So today we have two really amazing speakers that are here to help with the law of fashion, or fashion law, sorry, because it's something that a lot of fashion designers have issues with. So our first speaker is Anna Radke, and she's a managing associate at Brand Council. This was previously the Fashion Law Group. Brand Council, sorry, is a law firm that handles legal issues concerning art, media, sports, the tech industries, as well as corporate and personal brands. Anna is originally from Poland, and she moved to the US to become a fashion expert. So she graduated from FIT, which is the Fashion Institute of Technology in New York, where she majored in fashion merchandising and management. No, sorry, fashion merchandising management. So her interest for in becoming an attorney was piqued here by one of the professors at the institute. So she has a Master's of Law from Cornell University, and as a managing associate of Brand Council, Anna reviews bylaws and corporate governance issues. She also files trademarks, gets them protected, and handles business immigration issues for creatives. And Anna is licensed to practice in New York. So I think there's a whole lot we can get from having Anna here. And the second speaker is Liz Lenjo, who is the founder and managing consultant of My IP Legal Studio, which specializes in intellectual property, entertainment, media, and fashion law. So Liz serves in the Kenya Fashion Council as head of intellectual property and policy in the legal committee. She also is an adjunct faculty member at the Strathmore University Law School. She has a Master's of Law in Intellectual Property, among other wonderful achievements. And she also has a certificate in fashion law. She's a published writer and has been recognized for her efforts in the legal field. Most recently, she was recognized as one of the top 25 women in digital in Kenya for her intellectual property advocacy in the online space. So there's a whole lot more you can learn about them after this. And so I will now hand the floor over to Anna, and she's going to lead us off with an overview of fashion law. And then after that, Liz will present us with some case studies in this area and then there'll be a Q&A. So enjoy.
Hi everyone. Thank you so much for joining today, and thank you, Buff, for the introduction. I'm happy that I can connect with you today. Also, I hope that everyone's staying and your loved ones are staying healthy and safe during these difficult times. Um, so today we're going to talk a little bit about intellectual property in the fashion business. Um, I've been practicing law for over 5 years now, and I've dealt with a lot of different fashion businesses, and I think that intellectual property protection is what is actually the most important, because the value behind your brand is actually in your intellectual property. So today we're going to discuss basically 5 different buckets of intellectual property. We have trademarks, copyright, patent, trade secret, and right of publicity, and hopefully this will help you understand the case law that Liz is going to discuss. So let's start with trademarks. What are trademarks? Basically, trademarks are source identifiers of different brands. So here I have a couple of examples for you. We can have design marks, which are logos of companies. I included Chanel logo here. We also have word marks. So textual marks, just the name. It can be in stylized font. If it's a stylized font, it will be considered a design mark. Generally, I recommend clients to start with protecting the text, the name of the mark, because your font might change, your logo might change, but you first want to protect the name itself because it provides you with the most versatile protection. And then we have hybrid marks. So basically, the textual portion of your mark combined with the design component. So you can also think about Nike. Nike might have started with protecting Nike as the word, then they protected their logo, the swoosh, and then Nike also has registration of hybrid marks, so logo combined with the textual portion of the mark. Another important type of trademark in the fashion industry include colors. So I think that one of the most popular colors that is protected is Tiffany's blue. However, in order to protect colors as a trademark, they have to achieve secondary meaning. Secondary meaning means fame. So the consumers must be able to identify this particular color with a particular brand. So Tiffany Blue achieved registration because Tiffany, the company, was able to show that whenever consumers see this shade of blue, they associate with the brand. So next, I would like to discuss a little bit the registrability of the mark, because not every mark is able to gain protection, and it's actually very important to understand the basics of trademark law to choose the right name for your brand. Obviously, I already told you that probably the name and the other aspects of IP are your core values of your brand, because you're able to monetize them. So choosing the right name from the get-go is really crucial, because you don't want to invest thousands, into marketing if you know that the name is actually not available. So in order to register the mark, first of all, it has to be a mark that no one else has used before. So it can't be similar, confusingly similar with any other marks out there. However, when you find a mark that's not used out there, it also has to be inherently distinctive, meaning not every word can be protected. Under the US law, marks that are inherently distinctive include fanciful marks. These are words that are completely made up and don't exist in the dictionary. Arbitrary marks are also inherently distinctive. An arbitrary mark is a word that exists in the dictionary but does not describe your goods or services. So for example, Apple for computer services would be considered an arbitrary mark because consumers cannot connect Apple with computer services. These services are completely unrelated. And the third type of mark that is able to be registered is a suggestive mark. So basically, a mark that just alludes um, to the goods or the services that you offer. So, for example, a mark called Unscared for a fashion brand might be able to be considered suggestive. However, the difference between suggestive and descriptive marks um, is really thin, and descriptive marks are not able to be registered without achieving secondary meaning. So it's exactly like with colors. If your mark is descriptive, meaning it somehow describes the goods or services that you offer and won't be able to achieve registration until consumers are able to connect your particular brand with this mark. So, for example, if you want to call um, your brand a fashion brand, you won't be able to do it. You won't be able to register it as a mark because it's descriptive, and it will have to achieve secondary meaning before the US Patent and Trademark Office registers it. Another aspect of registrability is the fact that marks that consist of only of a surname are not able to get registration unless again they achieve secondary meaning. So if I wanted to register my name Radke as an apparel brand, I wouldn't be able to do it unless I show again the fame of the mark. However, you can register your first name and the last name. This type of combination, the US Trademark Office considers to be inherently distinctive because you're connecting a surname with a first name. However, when you're registering, and it's very common actually in the fashion industry that the brands that you use just your own name to run a brand. So then you want to consider to register this brand under your individual name and not under your entity name, because let's say you decide to sell your brand in the future and the trademark is owned by the entity, you're going to sell the rights to the name as well. It happened, for example, to Kate Spade. Kate Spade sold her own name, then she wasn't able to use it. She started a new brand. She had to call it Frances Valentine because she lost her rights to the mark when she sold her company for the first time. So just remember, you can just register your first name, last name under be an individual owner basically of your name. And then maybe you can license it in the future when you're trying to sell your company, so be able to monetize not only because of the acquisition of the brand, but also some royalties because of the option to license your name to the brand. When you're filing for a mark that includes or that consists of your name, you also have to submit a consent of a living person. Basically, you have to say that you agree to use and register your name as a mark in the future. Again, it's because you don't want any other people to register your name. You have, the first right to register it. So this is why the agency requires this requirement. And final aspect of registrability that I wanted to discuss is just the geographic designation. So basically, the mark should not include the names of the location where the mark is being made. So a lot of marks that say, I don't know, Radke, New York might have to be disclaimed, or maybe I'm calling my brand Radke New York, but the brand is based in Poland. Then it's going to be considered misdescriptive, and the agency might not be willing to register your marks. Another question that I get from designers a lot is the difference between these little logos next to the brand's name. So we have TMs and we have this R in a circle. So TM is used when the mark is pending. So let's say you file the trademark application, it's pending evaluation, then you can use this TM, meaning you haven't obtained registration yet, and R in a circle is only for marks that are already registered. So this is the difference. Basically, you're putting people on notice that you're protecting rights to your trademark. So the second bucket of intellectual property are copyrights. Copyrights are original works of authorship fixed in a tangible medium of expression. So we have 2D designs on clothing, we have photographs in the fashion industry, and we have jewelry. In the US, unlike in Europe, fashion designs are not protected. You can only protect conceptually separable elements. So for example, when you have a t-shirt with a graphic on it, you can just protect this graphic as a 2D design. When you have a fabric with some sort of original pattern, you can protect the pattern of the fabric. Or let's say you have a belt, if the buckle of the belt is original, you can protect it as well. However, the silhouette, the design of the garment, unfortunately, is not protected. What is important in the US, and not a lot of people know it, is the fact that copyright registration is a prerequisite to a copyright infringement lawsuit. So if you want to get a lot of damages, you have to have a registration prior to infringement. So if you ever think you'll be selling something to the US market, I highly recommend obtaining this copyright registration. Is not extremely expensive. You can file group registration, so register multiple designs at the same time or multiple photographs at the same time, and you might be able to win up to $150,000 in damages if someone infringes on it. So it's important to know, especially for international brands. So here I included examples of what can be copyrighted. So for example, on the left, when you have this butterfly and those flames and roses, these are graphic elements, they're original. When I file with the Copyright Office will register this graphic as a 2D design. Similarly, on the right, all these little graphics on the sweatshirt are protectable by copyright law. Potentially the plaid fabric on the skirt. And then we also have this backpack that looks like a bear. Here, the US Copyright Office won't grant copyright registration for this bear because it's a useful article. And for useful articles, we have different types of protection. We have patents. There are two types of patents. We have utility patents that protect solutions. So here I included a drawing of a patent. It was a self-lace shoe filed by Nike. Utility patents are protected for 20 years, so it's not indefinite protection. And also we have design patents for very novel and non-obvious designs. So I told you that generally fashion designs are not protected by copyright law, but if they're really novel and non-obvious, they can be protected by design patents. However, obtaining patents is extremely expensive. So I only recommend filing for a patent if you think that this will be like a design that you'll be using in every collection. So for example, here I included Carl Gaia's signature bag. And for example, Hermes Birkin bag has a design patent as well. And design patents last for 14 years only. So it's not a very long period of time. Then the fourth intellectual property bucket, we have trade secret. Trade secret is basically something that is not protected by trademark, copyright, or patent. This includes confidential information, so processes, ideas, methods, and any other information protected by other IP branches. So for example, I told you that fashion designs can be protected. That's why I recommend fashion designers signing NDA, non-confidentiality agreement, non-disclosure agreement, or confidentiality agreements with manufacturers. Basically, a manufacturer can steal your idea because, again, the silhouette of the garment is not protected by other types of IP that might attach right away. but you don't want the manufacturer to show your drawing to other brands. So this is why it's important to sign an NDA with certain parties. Obviously, it's not easy because you might be a young designer that is approaching a bigger brand, and then you might tell them like, hey, I'm going to show you my designs if you sign this NDA. Unfortunately, big brands sometimes are abusing it and they don't want to sign the NDA. And then you're going to have an initial meeting. They're going to say they love it. They're going to get back to you. They're not going to get back to you. And then they're going to use the design. It happens all the time. That's why NDA is important. But unfortunately, as a small player in the industry, sometimes you might not have the ability to sign it. So last but not least, I know it's a lot of information, but we have only 20 minutes, is the right of publicity. So right of publicity basically protects against the misappropriation of a person's name, image, and likeness. So here is, for example, a collaboration between a US brand and Bia, a rapper. So it was like a cross-license sort of agreement. Bia obviously granted her right of publicity. So her image, she's in the picture, she's promoting the campaign. Obviously, they're using her trademark here, Bia. And the collection is, the makeup line is called Beauty for Certain. It's her trademark as well. And then the brand actually created the entire marketing campaign, so they will be licensing Bia's the right to use these images. So you might have heard about all these cases now when, let's say, a celebrity is participating in a campaign promoting a brand, they being paid for it, and then subsequently the celebrity reposts the picture on their Instagram, and then the photographer or the brand goes after the celebrity and tells them that it's copyright infringement because the person was already paid for the project and now they're reposting images that belong to the company or to the photographer. But then all these celebrities have this defense of right of publicity. There have been a lot of cases recently with Ariana Grande, with Gigi Hadid, and they all settled. So we don't know how courts will decide in the future. However, when you're a brand, it's important to have a contract with the photographer, basically assigning all the rights to the images to the brand. So you don't want to be disputing anything with the photographer. And then you want to sign a release of right of publicity with the celebrity, so the celebrity then doesn't go after you and say that you stole, the rights of or her image. So this is it for today. Let us know if you have any questions. Here's also my Instagram, my email if you want to contact me. I also included a link to schedule a free consultation with me. I'm going to share it with Beth so they can maybe share the slides with you so you understand the basics of IP in the fashion industry.
Thank you so much, Anna. So now we're gonna have Liz come up with her portion of the presentation.
Thank you. All right. So I'll be talking about some of the mistakes fashion brands have made in the continent and internationally. And the purpose for this is just to learn from them. You'll find that sometimes as a fashion brand, being on a strict budget, on a, having been on a shoestring budget, so to speak, some of these lessons you can find them online. So that you protect your business and you can have a smooth sailing. So we'll start with a case we observed sometime in 2017. This is a designer, an African designer called Sarah Diouf. She had designed a Tongoro bag. It was a baguette bag. Unfortunately, it doesn't seem like she had protected her designs. It made its way on a runway with YSL, and of course she was angry, and she was featured in all those media publications, including OK Africa, and this is actually a quote from her interview in OK Africa, where she said, "A perfect replica of Tongoro Voodoo bag, our signature accessory, and there is no chance they could have seen it elsewhere, because where else have they seen it? Seen a 10 by 60 long baguette bag before?" So I think one thing that we cannot stop to reiterate is that intellectual property protection is territorial. So as a designer, it's important that you understand and interrogate what is your business model, what are your markets, so that then you protect yourself in the relevant markets, and you ensure, especially if you're in business in those markets, you want to protect yourself, you want to ensure that you have, submitted to their laws. So for example, we've seen Anna has shared what the US practice is. So it's important that, between your local council and the US council, you're able to discuss the best strategy and the kind of protection that you would accord yourselves in the different countries that you identify your commercial interests. Otherwise, you will be in a similar situation as Sarah here, who ended up crying tears. Again, this is an important strategy when you are, going for Fashion Week. There are so many eyes there in the different fashion weeks that you'll be presenting yourself. So make sure that you are protected in that country, especially if they're the kind of designs that they would give you ulcers if they were infringed, So, once you know what is your golden goose when it comes to the designs that you have, please protect it. Otherwise, you'll be spending more money in hospital bills and, depression. Another interesting case, this is an American case. This was Louis Vuitton, and well, I never remember the Roman number, but LVLX111. So basically, this was a young designer, this particular shoe, the LVL. He is a young designer who came up with this particular shoe design with the metal plate at the front of the shoe. And then, unfortunately, Louis Vuitton made a similar shoe, which is below here, and he tried to sue. Of course, it was unsuccessful because, the court was struggling with whether this was a trademark infringement issue, a trade dress infringement. So with trademarks or trade dress, they fall under the same category, the same purpose. So the court was like, we don't see, what is the issue. So eventually he tried, through his counsel, he tried to claim secondary meaning. You've had Anna mention that. And with secondary meaning, there comes a lot of quote unquote responsibilities or obligations as a young designer. And, the court interrogated whether he had advertised his product, how much had he spent on advertising, were there any efforts to advertise so that his design was known or illuminated in the market. And of course, he didn't tick that box. Consumer studies linking the mark to the source, i.e. to him. Again, in this instance, their expert witness failed to demonstrate this. He had not done this particular situation. So basically here it means that you have to do a survey of some sorts and basically show that a good number of people, of consumers, can actually say that this is Liz's design or this is Udochi's design, Again, he failed to do that. Unsolicited media coverage of the product, there was none. Again, he failed to do that. Sales success, unfortunately, he's out of 1,000 shoes that he had produced, I think barely half of that number sold, and then the rest were donated. Again, did not help his situation. Attempts to plagiarize the mark, again, he was not able to show or to demonstrate. And then the length and exclusivity of the mark's use, again, he was unable to demonstrate that. The take home for this case at the end of the day is that it can't be a cheap state in this fashion business, unfortunately. So as a designer, especially if you are eyeing to scale up or attract celebrities, it's always important. And also, again, in this particular marketing strategy by LVL, what he did is that he used celebrities to market his shoes. Of course, that gave him a good number of Instagram likes. He had about 50,000 Instagram likes. He may have thought that was enough, but of course the US courts were like, no, not enough. So it's important that you have a marketing budget. Once you know what is your golden goose, you have to protect it with all you have. So this was an important case in my view. This is a case of the fabric design. So in most or majority of African countries, we protect them by, you can do copyright, you can protect it by copyright, or you can protect by industrial design, which is similar to the design patterns in the US, similar, but not so much. But, again, it's always important that after this, you're able to just have a look at what is the practice in your different countries, so that you just have a rough idea of, what kind of strategy you should ideally have. So in this particular case, it was Naeem Khan versus J. Cruz. Prints and patterns can be protected by copyright, as Anna said. And in some instances, it can be protected by trademark law or industrial design, as I have said. Again, it depends on the strategy. So that is why a fashion lawyer usually becomes important. Then you're able to identify the best strategy. Again, with the different designs that you will have, with the different creations that you will create, you'll find that every time you're creating, at the end of the day, it's important that you have this assistance, so that then you maximize the potential of your intellectual property. Otherwise, you get you might be a very unhappy designer. In this particular case, Naeem did not take J. Cruz to court. So again, in one of the dailies that reported this story, they said that maybe he took it as a compliment that J. Cruz had, borrowed his stuff. So again, as designers, please do not get tired. The more you protect, the easier it is for you to also lay claims. This is a cultural appropriation example. So I refrained from using the obvious of the Maasai blanket. So I decided I'd show you another example that happened, so that we also realize that as Africans, we are not the only brands that get into trouble. And also being aware that as Africans that traditional knowledge and cultural expressions, which is now, I think I should call it the newbie in the body of intellectual property law, that you have to be aware of as a designer and make sure that you have the necessary permissions, you have the necessary licenses if possible, and in the absence of legislation, because I think in Africa we have only 2 countries that have passed the Traditional Knowledge Act, which are Kenya and South Africa. So other countries are yet to get there, but because we already know that this right exists and conversations are still happening, as a brand, there are strategies you can enforce to protect yourself. So in this particular case, Michael Kors put on the runway this particular sweater or jumper, which apparently is known as a Jaegers. I think I pronounced it right. Anna will correct me. So Twitter was very angry. So apparently this jumper is a very old part of tradition dating back to the Spanish colonial era, very popular with the Mexicans. So of course, Twitter went crazy, the American Twitter specifically and the Mexican Twitter. And he was taken apart. We saw the same thing with Louis Vuitton and the Maasai blanket issue as well. So imagine what would happen to you as a quote unquote smaller brand infringing on traditional knowledge or cultural expressions of another community. So it's very important that you protect your brand. Don't tell yourself that I'm too small, quote unquote, to be attacked or to be for a claim to be laid against me. You'd be really surprised and you would lose a lot of money. And then I think this is my last case, which is Dolce and Gabbana versus a South African retailer called Mijou Bella. So Mijou Bella had previously called her retail brand Dolce and Banana. So she found herself in trouble because Dolce and Gabbana decided, they sent her a cease and desist, and they were basically going to take her to court, and it would have cost her about £8,000 to defend. So immediately what she did is that she rebranded her studio to Banana, or I think and Banana, and then she wrote I think like a letter and also something on social media to one of the partners at Dolce and Gabbana and said, "Dear Stefano, please let us be and visit us in Cape Town. I have always admired your famous sense of humor. So please, so present in your brand and in your designs." Again, they got lucky, I think, eventually. But you'll find that you will not always get lucky. You might get sued, and you can imagine the kind of liabilities that you will accrue. Again, when you decide to name your brand, say like Forever 21 or all these fabulous brands, please confirm whether they have been registered in your country, because if they have, then you're going to be in trouble in that regard. Again, you're going to really pay through the nose in legal fees and damages. Yeah. And then lastly, this is something I couldn't find a picture, but it's a case that we experienced in Kenya. Unfortunately, it happened to the same brand twice, Shop New Level. And they're one of our clients, and we have authorization to share this example because the CEO, Nancy Moy, is very deliberate and purposeful about Kenyan fashion designers also trying to assert and protect their brands. So at first instance, this happened in 2020 when COVID just hit, and online marketing was very popular. And she found her designs online. So many fashion brands and fashion retailers in Kenya were selling her clothes. And then unfortunately, what they would do is they would also use her pictures. And for Shop New Level, the CEO models her own clothes, her own designs. So they would use her pictures as well, shamelessly. So we would find that most of them would say, "Oh, I have no idea. I didn't know it was the manufacturer in China who sent me these pictures." And we had to educate some of these brands and tell them, what, ignorance of the law is not defense. A caveat emptor was published, basically a buyer beware notice. We published it on behalf of her company, basically telling people that if you see these designs that are not on her website or on her social media platforms, please know that they're not legitimate designs, they're knockoffs, and beware. So that helped her, and she was able to assert her strength and her brand in the space in Kenya. Then again, unfortunately, this year it happened again, but this time it was in regard to a print that she had specifically sourced. Again, there was a few issues, but because it was the first time we were seeing the print as was done by her in the Kenyan market, it got knocked off. She was getting, reports from, her people who are watching out for her brand. And these stores would basically say, it's the Chinese, they're sending us these things, they're sending us the pictures, we didn't even know it was you. So again, if you interact with fashion retailers who are your friends, I think it's important to tell them they should confirm whether these particular designs they are being sold to are actually original from the manufacturers, or they have licenses, or otherwise they would be in trouble. She did not pursue this time round, but if she decides to pursue, then she could have a claim. But again, remember Anna's presentation. Please make sure that you register. Registration is the greatest way to protect your business. And then lastly, but not least, is the issue of using our names. As Africans, we love our names. And we want to register them we want to use them as our brands. So as Anna said, the minute you do that, and then you end up selling, or you get an investor, they will want to tap into that, which means tomorrow, if you launch a new fashion design, you won't even be able to say, I don't know, Scots by Liz Lenjo or something, for lack of a better example. But if I already had Liz Lenjo TM, and then tomorrow I decide, I've got an investor and I want to launch something by Liz Lenjo, I can't even do that. So you have to be very careful. Again, the other issue is when you're using some of these surnames. As Africans, we have same names. There's your family members, there's your cousins, there's even other people in your community have the same name. So in such an instance, I would say please stay away from that unless you're ready to enter into a coexisting agreement, because that would now be the strategy. Because I cannot refrain Udochi from using her name just because my middle name is Udochi. I can't do that. It's not right. So again, it's something that we really need to be wary about. Yeah, so that is all for me in terms of the case examples and studies that we need to learn from. And I hope you have learned something. We'll share these presentations with Udochi to share with you, and they will also have my details. Thank you.
Thank you so much, Liz. That was great. Now we're gonna go into a few minutes of Q&A for all those that have been listening. If you have any questions, you can enter them in the chat, and I will read them out to our presenters today to answer. Or if you want as well, you can raise your hand, and I will call out your name, and you can unmute yourself and ask the question yourself if you prefer that method. And just to give us a chance to kind of gather our thoughts, I'm going to ask one question, or at least two questions. I have a lot of questions, but just to give us a chance to kind of gather our thoughts and start putting those questions together, I'm going to pose the first two questions. So the first question I have for Liz and Anna is, what are things that brands should keep in mind when they're engaging with third parties? Are there any particular actions or steps that we should take as fashion practitioners if we are engaging with other third parties?
I would say have a contract, so you might want to even have a contract with like your intern, your independent contractor, or even an employee, just in case, like to protect your designs primarily, or maybe some business information. When you're dealing with a manufacturer, you want to have a contract as well. Or when you're maybe dealing with third parties on some collaborations, you might want to have a non-circumvention clause in these types of contracts. Recently, my client, who's a manufacturer, was dealing with a third-party licensor. They were licensing different brand names to them, and then directly one of the brands went directly to the licensor, and the manufacturer just lost their profit. So you want to keep that in mind. Just to put something in writing. It doesn't have to be necessarily like a full agreement, but just put everything in writing. So even when you have a call, like I always suggest to my clients, just send an email afterwards, like, hey, we agreed to this, and that, just to protect yourself.
Right, thank you, Anna.
Just to add on what Anna said, sometimes depending on the stage in which you are in your business, please refrain from going to Google School of Law. We have seen contracts that we can't get you out of. So please, in some instances, please, always invest in protective lawyering. It's affordable. You'll be surprised. Because the minute we when we get into defensive lawyering and we have to absorb all your drama and get into fight mode, that's a lot of money. Anna will send you her legal fee note and you'll be like, oh my gosh, really? You don't want to be in that situation. So please, get a lawyer. Just because we said non-disclosure agreement and you go on and like, oh, non-disclosure, yeah, non-circumvent, Anna talked about it. Yeah, I think it checks. Woohoo! You'll be surprised. These templates are from different jurisdictions, different provisions. So please, it can cost you as little as about $100, $200 for a lawyer to assist you with that contract, especially on the African continent. I don't know about the US at the cost, but at least with us, for the lawyers who are startup friendly, like our firm, that's something we can help you because, we know your pain, we know how it would hurt. So please make sure you have those contracts. And again, if a party will not sign your contract, just walk away. Just walk away. Otherwise, you will spend money in for psychologists and psychiatrists and hospital bills, and you will not be a happy person.
Yeah, I second whatever Liz said, we are like a business insurance, so definitely just protecting yourself from the get-go is more cost effective than trying to resolve a dispute.
Great, thank you both for that. And that's something that we actually one of the initiatives that we want to take on to help connect those on the continent with lawyers that can help them get some of these things done, some of the contracts that we're talking about today effectively and at low cost to you. So as you continue to engage with us, this is something that we should be able to make available to you as fashion practitioners. So thank you for those answers. And I see that we already have some questions coming in, but I'm going to just ask one more, and then I'm going to take the audience questions. So my second question is, as brands who may be based in Africa or other parts of the world, when should we consider registering our trademarks, our businesses, or copyright internationally beyond our immediate home countries?
Should I start? So I guess from my perspective, the US is the first to use jurisdiction. So basically, you don't have to do it like right away, but whenever you're planning to sell in the US, then you should do it. Unfortunately, there's no universal trademark registration, so you have to register in different jurisdictions separately, which can get really expensive. For example, in the US, to file a trademark, it costs $250 just the filing fee for the patent office. In the EU, it's €850. However, if you ever plan to enter Chinese market, I recommend filing right away because it's first to file jurisdiction. So it doesn't matter that you used it first, you have to be the first to register there.
I think actually Anna has answered it well. Just always remember where you're manufacturing, also register, protect it, protect your works, protect your trademark beforehand, right? By the time you are going to the manufacturer, you already have at least your certificate, or the process is at least halfway. Otherwise, you'll be in trouble. So remember, it's the countries of commercialization, the countries of manufacture that would be tops first, and then the rest could follow. Again, remember that because, especially like trademarks, they're territorial, some issues can come up and you might not register in a different country, either because in that country, the translation of that word might be, against morality, it might mean some bad word, or there might be a similar mark already registered. So because of the likelihood of, confusing consumers, that would be a thing. So again, when you're expanding, those are some of the factors that you need to have in mind, so that you're aware from the beginning. If I'm going to go to South Africa, then maybe I might rename it a little bit and have it by so-and-so or something, right? But it's important that you register at the beginning, don't wait. Again, also please register before you put on social media. I know we always get excited. We're like, oh, have you seen my new designs? And a competitor is watching you and they're like, Udochi, I see you. So it's always important, you protect before you display it even to the public, to your fans on Facebook or whatever. Make sure you protect.
Great, thank you both for that. So I'm gonna turn it now to the questions that we have in the chat. So we have someone that's asking, what licenses should a design brand have? I don't know if this is the entire presentation. Again, if you can maybe just give us a brief just rundown of what the I guess licenses or registrations that one should look to have as a design brand.
Would you like me to go first?
Yeah, I think so. Yeah.
Okay. So I think first things first, please register your business. If you're not registered your business and you're making profit, my friend, you're in trouble. You're already contravening the law. You find yourself in trouble. That's one. So again, with the registration of your business, highly advise that you have a lawyer on board, especially for the fashion students who are present. Please have a lawyer to guide you, because you're able to understand which registration you should get and why, and how it can help you, so that then you protect yourself. I know we always run for business name first, but remember the fashion business is very high on liability. So if you register a business name is you and the business name are the same. It means if tomorrow you're in debt, you owe $1,000, it will be your property that will be attached when it comes to bankruptcy proceedings. I don't think you want that. Save some money and register a company. You're better off that way. If you want to be a not-for-profit or you're a charity fashion organization as well, you'll be able to be guided through that process. And then secondly, in most countries, you would need a business permit for your shop or your offices. Please make sure that you have them. If your country has exemptions, confirm the same, but a business permit is always important. Depending on the kind of fashion business that you are, you might need one of those, should I say, environment kind of licenses that deal with how do you deal with your, waste from your factory, how do you discard them and things like that. It's very important. I think those would be the 3 top licenses. And then now, of course, after you've protected your designs, then now you're in a position to now also license your work, license your designs, maybe even franchise your fashion house. But in the beginning, those are some of the 3 most important licenses. I don't know if I've left anything, Anna.
Yeah, so there are different licenses depending on jurisdiction. Like in the US, a big one is like garment manufacturing license. And with regards to licensing your work, your IP, just remember that, for example, when you're buying a lotion from Victoria's Secret probably did not manufacture this lotion. They licensed the name to their licensee to manufacture this lotion. So this is how you can monetize on your IP, how you can make money on your intellectual property. But you have to first have all these registration that Liz mentioned in place in order to do it. So just do it from the start, and you should be fine.
Okay, great, thank you. For the person that asked that question, I think Stephanie Joki, I hope that answers this question. If not, just feel free to mention or give more detail in the chat if that wasn't what you were looking for. Okay, so thank you guys for that. Next question we have is, does the cost of brand registration differ dependent on the size of the brand?
It's the same. So it doesn't matter if you're a small brand or you're a big brand, the filing fee for protecting your brand name is the same in the US.
And just to add, when we are registering trademarks, we have what is called an S classification, where you declare the classes in which you operate in. So for example, with fashion, you'll have the basic class for footwear, I think it's 25, if I'm not wrong. Then now, depending, like if you do leather goods, it's on another class. If you do jewelry, again, it's on another class. And sometimes it may depend on the type of material that you're using to make your jewelry. So it will depend. And that's just the filing fees, what we, in Kenya and other African countries, we call the statutory fees. And then there'll also be some legal fee, which, you negotiate with your lawyer. It may be subject to also some sort of a remuneration order, how lawyers are allowed to charge or bill, depending on the jurisdiction as well. So you have to be aware of such. But please remember, this is an investment. It's not money you're throwing away, you're actually investing. I always like to use this analogy that intellectual property is similar to owning a piece of land, because Africans, we love land. We adore land, So it's the same thing, but you have to invest. Just the same way you will pay money to own a piece of land, please put some money aside to register your trademarks, your intellectual property, and you have your certificates and assert your proprietary rights.
Great, thank you, thank you. Okay, so next question we have in the chat says, should one have non-compete clauses in all contracts with fashion company employees?
Actually, non-compete are pretty popular on like executive level. So your key employees, you might now want to have a non-compete with, I don't know, your seamstresses, So it really depends. And in the US, in some jurisdictions, a non-compete might not be even enforceable. Like in California, it generally has to be, basically just not too long. Like it should be reasonable in time in order to be enforceable. And again, I would just do it maybe with your key employees, like your creative director. You don't want them to go to another brand and just I don't know, take your designs there. But non-compete, in my opinion, is not a great restrictive covenant in the fashion industry. But again, you might want to do confidentiality in order to protect your trade secrets, your designs, and your business information with that person.
Can you maybe share a bit on what a non-compete is for those who may not be familiar with it in the audience?
Yeah. So a non-compete is a restrictive provision, restrictive covenant that doesn't allow your employee to work for other competing brands. So you want it to be reasonable in scope. So for example, you might not want to say like, you can't work for any fashion company forever because you worked for me. It has to be reasonable. Maybe you don't want to work for another women's wear brand, in New York, but or in particular region, like in that 200-kilometer radius or something like that. But it should be reasonable.
The position is the same with Commonwealth countries. Non-compete clauses can be very difficult to enforce, especially when they become restrictive. It cannot be, when it's found to be a contract in restraint of trade, then automatically it holds no water. So it has to be carefully drafted, and it may vary from the different levels of people you want to engage in your business. So asking, you have to ask yourself first, why would I need an non-compete with this particular person? And if yes, then how can it be crafted in a way that it makes sense and it's enforceable? And, so these blanket non-compete clauses, you will find at the end of the day, you might be in trouble. You may not protect yourself. And there's nothing much you do, even if you have the money to take someone to court. Why are you going to waste all that money just to be told by the court, oh, actually, it holds no water, I'm sorry. Actually, now you pay this guy for wasting the court's time, So please have a lawyer to help you with that. And just something else to add is that in my observation with some of the African brands, and especially in East Africa that I've worked with, they've been very shy from, they've really been refraining from having contracts with their seamstresses. Even the front office manager. So you find most of them are like, oh no, it's my cousin's friend, or it's my cousin, or it's my brother. Then they don't give contracts. And then the next thing they leave, and bam, they leave with the designs. They even have the designs that you discarded, you didn't want to use. You're like, no, okay, maybe this one will make sense. This guy has gone with all that, the whole design book. there was no contract. How are you going to help yourself? You probably decided not to protect these designs because you are like, okay, whatever, I don't think I want them. But now you have no contract. So I think it's always important to assert yourself as a business person in the fashion industry from the beginning, even if it's your mother who's your streams. So what does disappear? Yeah, even if it's your mom, it's your sister, please just have a contract. The family relationship and the business relationship are different, and you want to save your relationship, especially the family relationship. So just have that contract so that if it doesn't work, you're able to just say, you know what, mom, it's not working out. Thanks, but no thanks, and we're good.
So in terms of protecting your designs or your work from employees, so then what should be in that contract? Is it just a confidentiality agreement that they will not use your work apart from your own business? Or is it case by case?
So I'll say it's case by case, but of course, confidentiality. The non-compete may apply depending on their role, depending on at what point also you may anticipate they could leave. Remember, again, with the kind of personnel we hire in the fashion industry, sometimes they tend to be very whimsical. Today they want a job, tomorrow they're like, no, I'm moving on, you know. So when you anticipate such, we're able to find some of these clauses to help you. So again, it's always important in that clause, in the contract, you're also specific in terms of what they do and what they have access to, because we've seen some contracts not being enforceable because they were too blanket. You know, you're trying to get the accountant, you know, to something like you've not shown or demonstrated in the contract that the accountant also gets to be privy to some of the design work or something, you know. So again, the contracts, I mean, the clauses, we get to have a look, because again, it will depend with how you run your business, how you envision, because again, creatives always come up with very interesting ways of doing business. So we find, we get to tell you what makes sense and then what doesn't, and then you find middle ground depending on how creative and out of the box you want to run your business.
Great, thank you. So just one more question from me. I don't know if anybody else in the audience has any more questions before we close this out. One more question from me. You talked a bit about the Traditional Knowledge Act that I think is in place in Kenya. Can you talk a bit about that and how it's helping to protect, I guess, African fashion brands or businesses?
Okay, so I think the consensus that we have, especially in Africa, is that you know, we passed a protocol. We call it the Somkonkud protocol, and it's about TK and TCEs. So we basically agreed that the communities own some cultural property. In light of this particular protocol, which is an international instrument, a regional instrument, you know, we are seeing countries now pushing forward to have their own local laws. However, because in the absence of an international treaty, especially specifically under like WIPO, for example, where we'd have like all these countries around the world submitting to, we are finding that these laws are likely to mostly be local. But because of the kind of noise that has been made, it's also boosting compliance with the international community, because nobody wants bad press. We're all moving towards, you know, consumers are very concerned about sustainability, you know, what's it called? Ethical fashion, you know, so people are very keen on that. So you find that now the brands are also being aware. One of the key principles for TK and TCEs is that there is, you know, the community is recognized and there's some benefit share. The benefit share can be monetary and can be non-monetary. But non-monetary could mean, you know, setting up a factory, giving employment. You may contribute to a certain cause in that particular community, and you protect yourself. So with that kind of information already beforehand, you'll be able to just have contracts anticipating this kind of legislation in your country, and then you save yourself, you know, any trouble or any drama in your particular country. But again, it would also be prudent that you sign it with the right people so that you don't find yourself in trouble. So which means you would have to include either the community leaders, are they organized in a way, or even the national government and figure out how you can negotiate that license beforehand, depending also on how complicated some of these communities may be organized in the different countries that you're going to try and use some of their TK or TCE in your brand.
Great, thank you. I think we have a comment from I think Max or Marx in the chat. It says, in addition to TK/TCE just discussed, is there a place for other IP rights like geographic indication and trade secrets and protecting fashion brands? I'm not sure if you got that. Let me read that one more time. In addition to TK/TCE just discussed, is there a place for other IP rights like geographic indication and trade secrets and protecting fashion brands? This is very technical. I'm not sure if I even understand.
Okay, I can take that.
Sure.
So with geographical indications, it will depend on your jurisdiction and whether they have a Geographical Indications Act in place. Unfortunately, we don't have many African countries who have the GI Act. I feel like we are missing out, but I've been in conversations where some are of the view that Africans don't need it, that the GI only applies to wines. However, we have seen fashion brands having GIs. For example, the Ilets lace in Russia. I think there's a Venetian lace as well. I forget the name, that's specifically named after a particular place in Venice, and so many other. So I think, for those of us who are yet to have GI legislation, like Kenya, for example, we're really missing out, at least in my view as an IP practitioner. When it comes to trade secrets, let's just say it can be a very expensive affair, and at the same time, does it make sense? Looking at the kind of, what's it called? The kind of quote unquote secrets that are there, how secrety are these techniques in the fashion industry? So it will depend, but to enforce trade secrets takes a lot. Like, I'll use the example of how Coca-Cola manages to keep their formula a trade secret. Like, they spend a lot of money. Like, they have even inspectors who go around and just check into a kiosk and they're like, okay, this is the legit Coke that should be served in your country, because they're very key, and the strategies that they have are also quite impressive. The kind of Fanta that we drink in Kenya is not the same Fanta that you find in New York, but it's the same Fanta you find in Mexico. I found out that when I was traveling. So, but so trade secrets are very tricky to enforce. If you can, fine, but just be ready to also pay your lawyers, because it means the legal team is always, looking out for you, and they're always, your police people on the ground. Yeah, I don't know, Anna, if you'd like to add something.
I think you covered it all. This is what it is. But yeah, trade secrets are extremely challenging to protect, because you have to keep it secret in order to maintain it.
Okay, great. So one last question so that we can close it out and have everybody get back to the rest of their days. I'm sure we can stay here forever answering questions. So we have one question in the chat that says, and this is a good question, how can designers use inspiration from a community without being accused of cultural appropriation? For example, a designer from a different tribe, same country, a luau making Maasai inspired jewelry.
Yeah, it's a very difficult topic, and it's very real. So for example, recently there was a case because David Yurman, a jewelry brand in the US, they used a design of some sort of Mexican local designer. So, in this case, obviously jewelry is subject to copyright protection, but copyright protection is very limited, meaning it's not forever. It's not like a trademark that you can renew. So let's say maybe the design has been around in the Mexican culture for more then the copyrightability period, right? So what happens? It's very difficult. They just took this design because basically maybe the design cannot be protected. Similarly, recently, a client used a design from a tribe in Panama, so in South America. And obviously, she's from Panama herself, even though she lives in the US now, but the design itself couldn't be protected by copyright because it's been used there in this particular tribe for ages. But she wanted to, somehow attribute the community. So what she created is she's going to um, designate a percentage of her profits to this community so they can continue developing their arts. And then she wants to approach the government so maybe they can create some sort of program so that supports the community and their cultural heritage, and basically helps them financially as well. But this is a very difficult topic these days, and I know that a lot of people are working to make it better. There are some attempts to introduce an act in the US, but we'll see what will happen.
And just to add, I think right now the greatest challenge that we are experiencing when it comes to matters TK and TCE is the documentation, because there has to be some documentation process to have that will happen where communities actually declare what it is that they own. When you look at how diverse the different African cultures are, we have a lot that we have in common that we share. If you just look at the kind of beadwork that we do and comparing just the Maasai, the Kenyan Maasai and the South Africans, if you just look at their beadwork, already, we would have to be a conversation. Then we are able to declare. Because that hasn't happened yet, it's a hit and miss kind of situation. But it's very hard, to walk away clean, saying, "Oh, it was just by inspiration." When it comes to TK and TCEs, I think just do what I said. If you must be inspired, just figure out how you work with the community, work with what we have, and then at least it will be a much cleaner affair. So if you already know what community it is that you want to work with or you want to be influenced by, just find a way to make them part of you and they benefit. And then by the time even the law is catching up officially, at least you will not be found to be in breach. At least you'll be okay. And it's also right. It's only prudent that if you're going to use, work property from another community, that you find a way to compensate them. The good thing is the TK movement, the TK rights are flexible. They're about both money and benefit sharing. So at least it's open, yeah. Again, the other thing is the issue of ordinary use. We are seeing that term being used when it comes to the context of traditional knowledge and cultural expressions. And ordinary use simply means also myself from my community. If I use this particular property, if I was Maasai and I'm wearing this Maasai necklace, is this ordinary use or, something like that, right? Again, we are yet to officially have those, especially in the Kenyan context, what ordinary use means. So that is something that you want to be, to do side by side with a knowledgeable IP council so that at least you protect yourself. For Kenya, we are working now on our regulations. So we hope by the end of 2022, we'll have regulations, because for the local businesses, we are finding a lot of challenges. Because you might register something in the IP office and they'll say, "Oh, you have this act. We can't register this until we know what we're doing with it," So, that's where we are. It's a developing area of law. So if you must be ready for that, those challenges, the ups and downs, be flexible, and please also don't get tired as a designer, because it happens. Like, the law is dynamic, so you have to embrace that.
I actually have a question for Liz, because I think it might be sometimes difficult, right? Because like tribes might live across different countries. Like I know like Fulani in West Africa, they might be like 3, 4, 5 different countries. So I don't know if there's a way for like governments to work. I mean, in Africa, I think it might be difficult because of like post-colonial era and like how the borders were divided and tribes might have been separated, right?
Yeah, so right now, actually, one of the things we are telling the Kenyan government is that we have to have those conversations. Key point, like for us, the Maasai tribe is also in Tanzania. So we're like, okay, so it doesn't make sense that the Maasai in Kenya will benefit to the detriment of the Tanzanians. So a conversation has to happen even in absence of a Tanzanian legislation. So again, those conversations I think are yet to really brew and happen. I think because people are still stuck with, what about us kind of conversations. But I think it's time they have it in the context of everyone else. If we just look at language, because for example, one of the rights that we are asserting over TK and TCEs is language. Okay, if you ask me, I think it's ridiculous because trademark law thrives on language, man. So, but now if there's some words I will use that you'll find even in some of the Nigerian tribes, they have the same words. So does that mean I can't use that word? There's so many things that I think in terms of language, we didn't really think about. And I'm hoping we are not going to wait to find out, that we sort of, intervene before that. But, outside language, everything else I think is possible. Language, I think, even as we're using English, it's borrowed from German, so we're going to start paying the Germans, So I think when it comes to language and asserting TCEs, I think there we kind of missed the plot a little bit. Yeah.
Great, thank you so much to Anna and Liz. This has been a great time. Thank you guys for taking the time to share with us today and for all the insights that you have shared today. As was said before, as follow-up for this conversation, we're going to send an email and we'll share Liz and Anna's contacts so that you can follow up with them if you want to ask more questions. Put them on social media so that you can continue to learn and engage with them on items that they post. So thank you again to Anna and Liz. We're so happy that you're able to be with us today and to really share what you know in this area with us. I also want to once again just thank the members of our team that were helpful in putting this together. I mentioned them before. Bias in African Fashion is the lead organization on this, and we are an organization dedicated to helping ensure that the fashion sector in Africa is open and inclusive and free of abuse and prejudice for all to take part in the industry. And then, of course, we have my IP Legal Studio represented by Liz, one of our speakers, who's going to be closing us out shortly to talk a bit more about some of the events that we have coming up. Also in this track of African fashion law. And then also Paul, who was on earlier, who introduced our speakers, fashion designer based out of Nigeria. And then last but not least, to round out the team is the Fashion Law Africa Summit, who is led by Sana Ahmed. So with this, I also want to thank those in the audience today. Thank you for taking the time to join us today, for taking time from your Saturday to really invest in yourselves, to invest in your businesses. It will definitely pay dividends. And please just stay in for a few more minutes as Liz shares with you the events and sessions that we have coming up in the future to help you do better, to do more in this area of using the law to really protect your businesses. So I'm going to hand it off to Liz to just close us out from here.
All right. So I think first we say thank you for showing up, for coming to learn, for investing in yourself. It's very important. For those who missed, if you know your friend who was registered and they missed out, please tell them that they missed out. In April, we'll be launching a fashion legal clinic. It will be a 3-day event where we'll have access to lawyers. There will be a process in terms of how you'll be able to be part of the legal clinic. So keep your eye out for the registration process, for the application process, so that you can be a part of it. And then we'll have about 3 days where the lawyers who are volunteering for the program will be able to slot you in. So the sooner you register, the minute you see the call out, the better. Of course, if you have attended our sessions, you'll have precedence in terms of being part of the training. So congratulations for those of you who are here already. Yeah, so more information will follow. And then we'll have the launch of the Legal Advisory Network in August 2022. And we'll be seeing how this network will unfold because it's the first time we're doing it in the continent, specifically for the fashion industry. So we'll also be looking forward to some of your input and letting us know how we can better help you and assist you throughout the journey. And last but not least, I would like to thank Anna for joining us, for sharing with us her knowledge, her expertise. We thank you very much for being part of this, for believing in our vision. If it wasn't for, virtual, if there was a way I could send you like a basket, maybe we should look into having an NFT and we send you something. Or in the metaverse, who knows? But thank you so much. We value your time and your expertise, and we look forward to interacting with you more. And all the best to the rest of your day. And to all of you who are here, enjoy the rest of your day. And for those who are about to go to bed, good night. All right.
Thank you. And I think there was a question in the chat about how you get recorded. We'll definitely also email that on. So, but thank you everyone for joining today. And look forward to having you at our upcoming sessions. Take care.
Thanks, everyone. Bye.
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 Bye. Thank you.
Thank you.